Good afternoon. I hope this finds everybody healthy and safe. I want to begin with just announcing that this is the first day of National Pro Bono Week, and I want to take a moment to thank all of our students for the terrific pro bono work that they're doing. And I always like to say we celebrate Pro Bono Week during this week in October that's designated by others, but we do pro bono work all year long because we're Berkeley Law and that's who we are. Our public mission is so central to all we do. And I also want to take a moment and thank Deborah Schlossberg, who does such a terrific job as our director of pro bono programs. When I first moved to California in 1983, I was surprised at the next election that came to get a phone book size thing in the mail. Now I say that, I don't know if people remember phone books, but it was amazingly thick, containing all of the initiatives that were going to be on the ballot. I had never lived in a state that adopted laws in this way. And one of the things that's bothered me over the years is how often people are asked to vote on initiatives without a clear understanding about what they're about. And if you just follow the ads on television, you often can't tell or even get a misleading impression of what they're about. Sometimes they deal with very complex issues of law. Last week, we had a wonderful panel discussion on Prop 16, which would amend the California Constitution to repeal Proposition 209 with regard to affirmative action. Today, we're going to focus on 3 other initiatives that are on the November ballot. And there's an article in today's LA Times talking about, for some of these, how the polling is very close. So it seems particularly appropriate to have in-depth discussion about them. I'm going to introduce the 3 speakers at the beginning and then turn the program over to them. And as always, if you have questions, just put them in the Q&A, and then we'll have plenty of time for questions at the end of the session. We talked before starting as to what order to do this, and we decided to do it by numerical order of proposition. So I'll introduce the speakers, as I said, in the order in which they're going to be addressing us. Starting with Proposition 15, that involves taxes. And we're very fortunate Jesús Quiñonez is our speaker on this. He's currently the legal director of the California Teachers Association, CTA. CTA chapters serve as the exclusive bargaining agents of teachers and other academic support employees in over 950 California schools and community college districts. Prior to working for CTA, Jesús practiced union-side labor law for over 30 years in 2 Los Angeles area law firms. He attended Harvard College and is a graduate of UCLA Law School. The second speaker will be on Prop 22, which concerns ride-based apps. And for this, will be Professor Catherine Fisk. She's the Barbara Nachtrieb Armstrong Professor of Law at Berkeley Law School. And she's been here since 2017. Before that, she was a Chancellor's Professor at the University of California Irvine School of Law. Before that, a professor, the Douglas Maggs Professor of Law at Duke Law School, a professor at USC and Loyola. She's the author of many books and articles, especially focusing on labor and employment law. And then we'll hear about Proposition 25, which focuses on the issue of money bail and perhaps some of the other initiatives concerning the criminal justice system. Ahmed Lavalais is a clinical teaching fellow at Berkeley Law. He teaches in the Policy Advocacy Clinic. He supervises law and public policy students in the clinic's national multi-year campaign to eliminate monetary sanctions imposed on youth and families in the juvenile legal system. Ahmed's scholarly interests in advocacy work include youth justice, combating state-sanctioned violence against communities of color, and abolitionist theory. He's previously worked on projects seeking to increase support services to commercially sexually exploited children, to end the use of solitary confinement against minors, and in efforts to eliminate the use of cash bail in delinquency cases in Louisiana. He graduated from UC Berkeley with honors with a BA in philosophy and earned his JD from Berkeley Law, where he's a National Jurist Law Student of the Year. So with those introductions, we'll begin with Jesús. And again, thanks to the speakers for being here.
Thank you, Erwin. It's really good to be here this afternoon with good friends, and Thank you for inviting me. I'm going to talk about Proposition 15, which is about tax revenue in California. And I think we got to remember that tax revenue and tax policy reflects the community's shared effort to provide services to our people, to our children, to our elderly, to those in the most need in our society. And I think this proposition in particular really gives us all a chance to change some direction in the way that we fund public services, everything from schools to public parks, to public libraries, to public health. It's that shared commitment that I'm hoping everyone will keep in mind as they evaluate the merits of Proposition 15. Just so you understand the politics of it all, the Proposition 15 is endorsed by the LA Times, the Sacramento Bee, the San Francisco Chronicle, La Opinión, Governor Gavin Newsom, presidential candidate Joe Biden, vice presidential candidate Kamala Harris, United States Senator Bernie Sanders, the ACLU, the California firefighters, the SEIU, the PTA, and of course CTA, who I work for, the California Teachers Association, among many, many others. Prop 15 is opposed by every major statewide and regional chamber of commerce in the state of California, and is led, its biggest political endorser is a former governor by the name of Pete Wilson. In order to understand Prop 15, you have to have a handle on what happened with Proposition 13 42 years ago, 1978. So in 1978, property taxes had been going up much too rapidly, particularly for homeowners. And Prop 13 was an attempt to reform the residential property tax structure in California and protect residential homeowners, like my parents at the time, some of your grandmothers, some of your great-grandparents, etc. And it was intended to provide real meaningful reform and protections to homeowners in California. And what it essentially meant is that the taxable value of a property would be based on its original purchase price rather than its current market value. And during most of the late 60s and the 70s, property values had been going up fairly rapidly while income was not as rapidly increasing. And so that was really harmful to families who owned homes. So Prop 13 was aimed at fixing that. There was one problem. And the problem was that Prop 13 also included commercial property owners and industrial property owners. So they got the same protections and limitations on any increases that would commonly be included in their annual tax bills. And they were also to be taxed based on their commercial property prices at the time of purchase. And they were all reset to 1976 levels. So, for example, Disneyland started to be taxed at its 1976 value. And of course, they continue to own all of that property, Disneyland and Anaheim. And unfortunately, if you go to Disneyland these days, as some of you may have, if you've taken your parents or taken your children, you know that they don't have 1976 prices at Disneyland. You pay 2020 prices, but they continue to pay property taxes that are based on the value of their property in Anaheim, California, as of 1976. That might be good for grandma and grandpa, but it's not necessarily good for the communities that rely on tax revenue to provide services. So what else has this meant for our tax policy in California? Well, when the Sacramento Bee editorialized on Prop 15 on October 22nd, this is what they said. And I want to read this because I think it's helpful and instructive. It says, Proposition 15, and that's the Schools and Communities First initiative. It gives Californians a chance to fix one of the most glaring errors of the past 4 decades, a massive tax break for wealthy commercial property owners who can afford to pay their fair share of taxes. So that's what we're doing here through Proposition 15, is to amend the California Constitution to require commercial and industrial properties. It doesn't touch residential properties. Prop 13 remains in effect for residential properties. It would amend the California Constitution to require commercial and industrial properties to be taxed on market value rather than purchase price, while continuing to tax residential properties on their purchase price. So you all know that if you buy a residential property today, you're going to be paying taxes at a much higher rate than someone who bought in 1978. But what happens with real estate is not, with commercial property is not quite this. It is not quite the same thing, in that you have lots of large corporate property owners who continue who have amassed property that they had back in the late 70s, early 80s, and who have benefited from that loophole for so long. So the result of Prop 15 would be to equalize what large commercial property owners pay, so that they now pay at a level of other commercial property owners who bought more recently. So for example, in Silicon Valley, they actually are paying their fair share, because many of those companies purchased commercial property more recently in the 2000s and in the last 10 years, and they are paid in much higher levels than some very large corporations who, as I said, benefit from those 1976 rates that went into effect with Proposition 13. So the revenue generated from Prop 15 would be directed to K-12 public schools, to community colleges, and to local governments. The initiative exempts properties whose owners have $3 million or less in holdings in California. These properties would continue to be taxed on their purchase price. It also exempts businesses that operate out of residential homes, of course. They're exempted, so they don't have to worry about paying additional taxes. There are other protections for small businesses, including an exemption for home-based businesses, as I said, deferred reassessment until the 25-26 lien date for properties in which small businesses account for 50% or more of the occupied spaces, and the elimination of the business tangible personal property tax on equipment and fixtures for small firms. So built into Prop 15 is also some tax relief for all businesses that will be very beneficial to smaller businesses. There's no question, both sides agree that it will generate billions of dollars for education and for local services. The estimate is that it's roughly $12 billion a year. Opponents argue that that's just a tax increase, and that it's going to be harmful to all property owners. Now, you wonder why they can say that when it's expressly stated in the law that it will not impact residential property owners. And with respect to small businesses, it's also clear that there will be no impact if you, number one, if you own a business, if you own a commercial property that's under $3 million in value, you're exempt. If you run a business out of a residence, you're exempt. And finally, there are claims that because these large corporations will have to pay more, that's automatically going to be passed on to small business owners who rent from them. There's a couple of problems with that approach, with that analysis. One is that market rates for rental properties aren't based on what the owner pays in taxes. They're based on a bunch of other considerations of business considerations that apply in different settings. And as I stated earlier, there are a lot of commercial property owners now who already pay their fair share because they purchased their properties more recently and are paying at the actual market value. So, and there's no evidence to show that everybody who currently rents from a large commercial property owner whose tax status may change as a result of Proposition 15 is therefore automatically going to be passed on to renters. It simply doesn't operate that way. And there have been a couple of studies, one by Beacon Economics most recently that was done for the Silicon Valley Chamber of Commerce that helped to demonstrate that. If you go on the yeson15.org website, you can get access to that, and you'll see how it debunks that idea that this is automatically going to be passed on to small businesses. The fact that there's a phase-in of the law also allows small business owners, to the extent that they're getting squeezed by their landlords, they will have some time because of the phasing in of the new rates. They will have some time to look elsewhere, to go shopping for better rates, better rental rates, and to not be the victims of abuse by these large property owners who may want to pass on their own property tax increases to small businesses. Now, the reason there's such widespread support for Prop 15 is really the following. The impact of this structural problem that was built into Prop 13 by including commercial property owners and industrial property owners is that it starved the public sector. Throughout the 80s, through most of the 90s, through the budget cycles that we had to go through, constant layoffs in education, public employees were faced with massive cuts in public services, and includes public health, et cetera. This is really an attempt to make up for the lack of adequate funding for schools, for libraries, for public health, and other public services that we've been living under for far too long. And so when the Sacramento Bee says, now's the time to fix something that's 4 decades old, that's what they're talking about. So we're hopeful that folks will support Proposition 15 and fix these loopholes that have been in place for far too long. Thank you.
Thank you, Jesús. That was an incredibly clear explanation of Proposition 15. Proposition 22 has been put on the ballot through funding from Uber and Lyft, DoorDash, for the purpose of eliminating driver eligibility for state and local minimum wages, premium pay for overtime, paid sick leave, unemployment benefits, workers' compensation benefits if they're injured, health benefits, fare scheduling, disability insurance if they become injured for reasons not caused by driving, unpaid medical and family leave, or paid sick leave. It also will prevent cities from applying their laws to protect drivers. Furthermore, if it is enacted, it will deprive drivers of the right they have under California law to be compensated for the use of their vehicles in Uber and Lyft's business. It leaves drivers unprotected under the California Fair Employment and Housing Act against race, sex, religious, national origin, gender identity, disability, and other forms of discrimination or harassment. It prohibits the California legislature from giving drivers the right to unionize or negotiate collectively, and attempts to ensure that they will not have a federal right to negotiate collectively. And finally, and importantly, it prevents the California legislature from amending or modifying any of Prop 22's provisions, including from in the future raising wages. The only way the California legislature can change the law, according to the proposition, is by a 7/8 vote. That super majority requirement is far more than is required by the United States Constitution, even for an amendment to the US Constitution. So what it does is it entrenches this law into California law for forever. And it also prohibits, it changes ordinary legislative process by requiring that any bill to change it would have to be circulated with 2 weeks' notice in order that Uber and Lyft's lobbyists can be sure to mount an all-out lobbying effort to prevent a 7/8 majority from changing it. What does it give drivers in return? It gives them a statutory right to be paid 20% more than the state minimum wage, but only for the time that a driver spends giving someone a ride. All the time they spend waiting to be called will be uncompensated. And that's the key thing about Prop 22. It's what the companies are fighting so hard about. They do not want to have to pay drivers for the time they spend driving around or parked waiting for somebody to summon them on the app, or for the time they spend driving back to a place that they can pick up another driver if they had to take another rider, rather, if they had to take a rider to a far outlying location. It also commits the companies to provide a small payment to subsidize health insurance premiums under Covered California, but it does so only for those drivers who are actually providing rides for 25 hours a week per week during an entire 3-month period. Again, not counting the waiting time. And even for those drivers who manage to be providing rides for 25 hours a week instead of waiting, the companies will pay only 4/5 of the minimum cost of a covered California plan. For drivers who provide rides between 15 and 25 hours a week for a 3-month period, the companies will pay 2/5 of the covered California premium. And there will be no health insurance subsidies, even for those drivers who work full-time or more than full-time, but who don't manage to pick up rides for at least 15 hours a week for every week for 3 months. The initiative also commits companies to provide a limited form of insurance for driver injury, but only for injuries sustained during the time that drivers are on the app, not for other times. And of course, many driver injuries are not a sudden injury that happen while they're on the app. They are stress injuries or lower back injuries that are from sustained time. And so there will be plenty of disputing over whether the insurance covers the driver injury. And so, of course, what that means is that drivers are going to have to provide their own insurance. And then finally, the companies commit to conducting sexual harassment training and to investigate allegations of harassment, but again, gives the drivers no real protection against harassment or discrimination. What are the implications of the adoption of Prop 22 if it is adopted? Well, number one, the companies will not have to contribute to the California Unemployment Insurance Fund. Berkeley faculty economists have estimated that if Uber and Lyft had treated their drivers as employees between 2015 and 2019, they would have paid a combined $413 million into the California Unemployment Insurance Trust Fund. So that's money that hasn't been paid and is not going to be paid. Unemployment insurance in California is funded by a payroll tax of about 3.4% of the first $7,000 an employee is paid. So that's what pays the benefits. When the pandemic shutdown caused a massive drop in riders, drivers were ineligible for unemployment insurance because Uber and Lyft had not paid into the fund. Congress in late March enacted the CARES Act, which provided pandemic unemployment assistance for independent contractors, for misclassified gig workers, and for others who weren't eligible for unemployment insurance under the state plan. And Uber and Lyft told their drivers to apply for it. But what's troubling is that every other employer in California has to pay the payroll tax that fund the unemployment benefits. Uber and Lyft's position was that their drivers should get paid pandemic unemployment assistance funded by general revenues, that is, the taxes that the rest of us pay through income taxes. But Uber and Lyft hadn't been paying taxes to support the benefits that they asked Congress to fund for their drivers, so that this is essentially a massive public subsidy for these companies. The implications of treating Uber and Lyft drivers as independent contractors is that they will be paid less than the California minimum wage. Yes, the initiative requires that they be paid 20% more than the minimum wage during the time they are providing rides, but not during waiting time. And many estimates, in fact, all estimates by economists unaffiliated with Uber and Lyft or not paid by Uber and Lyft, estimate that Uber and Lyft drivers are already getting paid less than the minimum wage and that they will continue to be paid less. Uber and Lyft have funded studies by many respectable economists, I will say, purporting to show that they pay their drivers between $16 and $23 an hour. We don't know actually in California because Uber and Lyft won't provide the data, but we do know from what they pay in other states because they have provided some data for some other states. The problem with the Uber and Lyft funded studies, and the reason that their studies suggest they are in compliance with minimum wage law, but that independent studies show they're not, is that most of the Uber and Lyft funded studies do not count the waiting time, the time drivers pay waiting to be engaged. And because Uber and Lyft think their business model depends on drivers responding very quickly, being no more than 5 minutes away from wherever you are, even if you're in some residential neighborhood, not close to a major commercial center, they depend on a huge surplus of drivers on the roads because that's what enables the fast response time. And when there's a huge surplus of drivers on the road, of course, a lot of drivers are not engaged. They're just waiting to be engaged. And that means those drivers are not getting paid. Uber and Lyft have also argued in support of Prop 22 that it is necessary in order to protect the right of drivers who work part-time or sporadically to work flexible schedules. However, there is nothing in California law that requires independent contractors to work a set schedule. There is nothing that requires an employee to work a set schedule. Generally speaking, companies can set employee schedules any way they want. Some jurisdictions like San Francisco require advance notice a week in advance of the schedule that employees could work. And this, it is fair to say, could cause some problems for an app-based on-demand model like Uber and Lyft. But of course, that could be modified to have schedules that would work for Uber and Lyft's business model. But generally speaking, companies are perfectly free at their convenience to set work hours for 2 hours on day 1, 8 hours on day 2, to short shifts of 3 hours each on day 3, and change them as often as they want. And companies, especially in retail, do that so that they are staffed only as much as they need to match customer demand at any particular time. So Uber and Lyft don't have to go to a set 8-hour a day, 5-day a week schedule in order to comply with the law if their drivers were employees. They could do what McDonald's does or Starbucks or whoever and have very flexible and irregular schedules to match drivers to demand. What would happen if Prop 22 goes into effect? Berkeley economists have estimated that too. And what they have found is that Uber and Lyft will pay dramatically less than the minimum wage, and drivers will continue to be paid significantly less than the minimum wage. What will happen if Prop 22 does not go into effect? Well, if Uber and Lyft eventually accede to what the law is required of them for some time, it is estimated by Berkeley economists that employee status would increase total driver compensation by about 30%. That would include higher net hourly wages, mandated benefits such as workers' compensation and unemployment insurance, compensation for all the hours they work, and reimbursed expenses such as for the use of their vehicle. The companies, economists estimate, would continue to employ part-time drivers to meet large fluctuations in demand between peak and off-peak hours. So casual and part-time drivers could benefit because they would earn more by driving during off-peak hours, like weekday afternoons. Economists estimate that fares would increase slightly if drivers were employees, probably about 5 to 10%, depending upon how much the companies adjusted how they do commissions, and if they took less of the money that drivers get paid by passengers. Economists estimate that if drivers were required to be treated as employees, there would be reduced driver waiting time between rides, reduced turnover costs, and Uber and Lyft would take less of a commission on drivers. Economists estimate that passenger demand for Ubers and Lyft would not be super responsive to price changes. So Uber and Lyft are arguing that passenger demand would plummet and it would send the companies into a death spiral and they would have to leave California with our 40 million people. Economists estimate that a price increase of 5 to 10% would reduce passenger demand by only 1 to 2%. And finally, Berkeley economists estimate that the total company revenue would actually increase, not decrease, because the decline in the number of fares would be smaller than fare increases. And so that would result in higher revenue. Uber and Lyft, of course, dispute all of this, and you can look at the various studies and see which ones you find most persuasive. But ultimately, it seems to me, as with Prop 15, as Jesús Quiñonez just explained to us, the question, of course, is equity. There are a large number of Uber and Lyft drivers who work full-time. In fact, most of the driving done by Uber and Lyft is done by drivers who work either full-time or half-time. That the part-time and casual drivers who prefer their flexibility and who don't depend on earning the minimum wage in order to provide a decent income for their family work mainly on evenings and weekends during high demand times. And so there are a large number of full-time drivers who really depend on decent wages for a living for their family. And in the end, it seems to me, the reason why we have minimum wage is to ensure a decent standard of living for those drivers. And that's why it seems to me, and of course, that's why it seemed to the California legislature and the California Supreme Court, that the right thing to do is to treat this category of worker as employees rather than as unprotected independent contractors. Thank you. I think it's now your turn, Ahmed.
Thank you, Catherine. So before I begin, I want to acknowledge at the outset the split in opinion among left-leaning advocacy groups over Prop 25 and the deeply problematic nature of either outcome of the Prop 25 vote. There are understandable reasons to vote either way here, but whichever way this vote goes, a discriminatory law will be on the books. In addition, I should note that I myself did not participate in any of the advocacy on either side of this issue, though I know and respect people on both sides of the divide. So I'm going to spend a few minutes describing what Prop 25 does, briefly outlining the pro and con arguments as I understand them, and I will conclude by saying a few words about how I have been thinking about the issue. Given the time constraints, I'm going to avoid as much as possible engaging with the multitude of technical details attendant to such a complex and controversial proposition. I will try to focus on some of what I take to be the bigger picture concerns animating opinions for and against Prop 25, and I look forward to our discussion. So Proposition 25 is a referendum on whether to accept or reject Senate Bill 10, a 2018 law signed by Governor Jerry Brown, which was slated to take effect in the fall of 2019. A yes vote on Prop 25 means that no one would pay bail in order to secure release from jail before trial. Under Prop 25, persons accused of most misdemeanors would be automatically released. All other persons would be subjected to some version of risk assessment. Risk assessment instruments employ algorithms that their designers claim can predict the likelihood that a specific defendant will commit a crime or fail to appear in court. These tools assign points based on certain traits, such as age or prior contact with the criminal system, with a higher score indicating a greater probability that a person will commit a crime or fail to appear. A no vote on Prop 25 means that some people would have to pay bail if they hoped to be released from jail before trial. Risk assessment instruments could still be used, but would not be required. Put simply, a yes vote would eliminate cash bail and replace cash bail with risk assessment instruments which use algorithms to determine risk. A no vote would keep the current system in place, meaning that cash bail would still be available for courts to use in pretrial detention matters, and risk assessment instruments would be allowed, but not mandatory. For many, Prop 25 boils down to a choice between two acknowledged evils: the unfair, class-based practice of relying on cash bail to secure pretrial release versus risk assessment instruments that codify and legitimize generations of racialized criminalization and clothe racial stereotypes of dangerousness and criminality in a veneer of computerized objectivity. The cash bail industry turns the understandable desperation that people feel to free themselves from cages into billions of dollars in profit. And bail setting in California is particularly problematic, with the average bail amount in the state being over 5 times the national average. Cash bail blatantly privileges wealth. A low-income person accused of a non-serious crime can sit in jail for months, while a wealthy person accused of a serious crime can go free within hours of being arrested, simply because one person has enough money to pay bail and one does not. Unsurprisingly, bail setting is often applied in a racially discriminatory fashion. For example, some analyses have found that judges set bail amounts that are markedly higher for Black defendants than for similarly situated white defendants. Perhaps the most pressing arguments for Prop 25 are estimates offered by proponents suggesting that nearly 150,000 people who would otherwise be jailed could be allowed to go free pending trial. While proponents acknowledge the flaws of risk assessment instruments, those advocating for Prop 25 claim that removing the corrupting influence of the cash bail industry from California's criminal system is worth the trade. For their part, opponents of Prop 25 readily concede that cash bail and the cash bail industry are plagues that help perpetuate injustice and discrimination in California's criminal system. Opponents are most disturbed by the use of predictive algorithms, risk assessment instruments, as the mandatory replacement for cash bail. Risk assessment instruments take problematic notions such as age and the crime for which a person is charged into account when determining the likelihood that a person might commit a crime or fail to appear in court. Of particular concern is the fact that risk assessment instruments take prior contacts with the criminal system as indicative of higher risk. Given the prevalence of racial profiling and the long and ongoing history of racialized policing, discrimination on the part of prosecutors, judges, and juries, many advocates see risk assessment instruments as codifying and legitimizing the racism of mass incarceration. As you can imagine, in analysis of the details, there is much left to estimation, and definitive numbers are nearly impossible to come by. That said, proponents of Prop 25 leverage existing data to make a compelling case that a significant number of persons will avoid jail if Prop 25 passes. In light of the racialized brutality of the US carceral system, the prospect that tens of thousands of persons, principally low-income persons of colors, might avoid being caged has tremendous appeal. On the other side, opponents of Prop 25 point to a probable rise in the use of preventive detentions, meaning that different people would be jailed, but perhaps not fewer people. Efforts by both sides at quantifying the harms here take on a somewhat utilitarian note, that may miss something vital. The larger evil at work is an oppressive carceral system. Utilitarian style analyses seem a poor fit when engaging systemic oppression. Such oppression is impossible to quantify in terms of persons harmed, except perhaps to say that we are all harmed to varying degrees by the infrastructures of racism and classism. Yes, risk assessment instruments will unfairly punish some people, but proponents of 25 say we should ultimately choose the lesser evil of risk assessment instruments because doing so will result in freedom for thousands, and an extractive and parasitic industry will be pushed out of California. Opponents of Prop 25 refuse to accept a compromise which sweeps the racist laws, policies, and practices of the past under the rug, and even worse, makes yesterday's racism the vehicle through which today's supposedly neutral analyses are made. I am ultimately swayed by the latter of these arguments, but the choices here are far from ideal, and there are strong reasons arguing in favor of yes and no votes. Sadly, whichever way this vote goes, a discriminatory law will be in place, and low-income communities of color will, as ever, be those that suffer the most. Thank you for your time, and I look forward to the discussion.
Jesús, Catherine, Ahmed, those were just wonderful presentations on very hard issues. We have some questions that have come in. The first two, Catherine, are directed at you. Okay, let me do this. Flexibility of schedules under Prop 22. Right now, drivers can just hop on the app at any given moment to drive for however long. Would they, however long they want? Would that change? Even if schedules are allowed to be irregular, non-8-hour shifts, would predetermined shift time and length still be required?
Nothing in California law requires employees to work predetermined shifts or shifts that are determined unilaterally by the employer. So if Prop 22 does not pass, Uber and Lyft could still allow drivers to hop on the app and drive for however long they want. Just the only thing that might affect that is Uber and Lyft would be obliged to pay the minimum wage for all the time the driver spends on the app. And they would have to figure out a way to prevent drivers from turning on the app, but not actually ever responding to requests for rides and instead just getting paid to run their own personal errands. That's a technical problem that they could fairly easily solve, it seems to me, although I'm not an engineer. So yes, people could still jump on the app and drive. I imagine Uber and Lyft would restrict the number of hours they could do that so that they don't have to pay any overtime. But already employers routinely prohibit people from working more than 8 hours in a day in order to avoid having to pay overtime.
Catherine, the next question comes for you also. It said, Uber and Lyft has said that they will leave California if Prop 22 does not pass. Is that a realistic threat?
If Uber and Lyft decide to leave California, they will be leaving the 40 million people in California who like app-based rides to their competitors. And I am 100% sure that somebody will come into that market and figure out how to provide rides at a price that consumers want to pay. I think it's an empty threat. I don't think they would really do it.
The next question is, whoops, I think it's okay. Can Jesús or any other panelists also speak to Prop 19 at all? Jesús or Catherine, Ahmed, anybody else speak to Prop 19?
But if somebody wants to send me an email, I'll be happy to have a conversation with them individually. I'm just not prepared to speak on it now.
Yeah, I wouldn't want to do that either, in fairness.
Ahmed, did you want to speak to any of the other criminal justice initiatives?
I mean, beyond 25, I know there was some discussion of us talking about Prop 20, which increases the number uh, of crimes that are considered felonies and changes the potential punishments for them. For my part, I take that to be a fairly obvious no vote. Of the criminal justice related propositions, it is undoubtedly for me Prop 25 being the one that I've had the most difficulty with. There are very strong reasons, I think, for voting in either direction here. The cash bail industry is deeply parasitic wherever it exists. It helps perpetuate mass incarceration and has done so for many decades. But risk assessment tools, as I mentioned, absolutely, as currently constructed, serve to codify patterns of racism, and that in and of itself is also problematic.
I got two other questions for you. One is the California Court of Appeal in the Humphreys case struck down money bail. That is pending before the California Supreme Court. What would be the effect of passing Prop 25 on that case?
I am not sure. I'm sorry to say. Yeah, unfortunately, I'm not prepared to fully answer that question. I wouldn't want to speculate.
I have another question. Let me just make these. If money bail and risk assessment tools are both undesirable, what is the solution for deciding who should be detained?
That's always the question. And I should just say before I answer that, anything I say here is likely to be unsatisfactory. The sort of broadest 30,000-foot answer is something along the lines of dismantling a historically racist carceral system. Beyond that, I think where many advocates have landed, including as it relates to the bail reform effort in New York in particular, the reforms have been centered around decarceration. So the reforms in California, at least as they were ultimately presented in the bill that was signed into law, were oriented around calls for public safety. The reforms in New York were largely oriented around the goal of decarceration. The idea being that the reforms in New York were centering the idea that we must do everything we can to avoid putting human beings in cages. That I think is a likely starting place. Again, an unsatisfactory answer, but I think suggests a way of reframing the conversation that opponents of Prop 25 is of SB 10 is currently constructed that I think they would endorse.
Thank you. The next question, like this is for Catherine. Do you know anything about the lawsuit by app drivers about an in-app survey that asks drivers to endorse Prop 22 before they get onto the app? The company then uses the survey response for high approval ratings. It seems like both an unfair hoop for drivers they have to jump through and very deceptive advertising.
And I think it's a pretty clear violation of California Labor Code section 1101 and 1102, which prohibit employers from coercing employees' political activities. A requirement that an employer imposes, and remember, unless Prop 22 passes, Uber and Lyft are employers of their drivers, according to the California Court of Appeal. A requirement that you express a particular political point of view as a condition of employment is a flat out violation of California law. And this is a law that's been on the books for decades. So I would give that lawsuit a fairly good chance of success. And yes, of course, it's also deceptive for employers to coerce their workforce into expressing a political view and then present the coerced expression of a political view as a reason why the public is only doing what the drivers want. It's unbelievably cynical and illegal.
Jesús, the next question we got is from you. Does Prop 15 go far enough in reforming Prop 13?
Well, by creating what's known as the split roll, it certainly makes up for that massive loophole that was created by the original Prop 13 with regards to industrial and commercial properties. There can probably be a good debate over whether residential property owners should continue to benefit from the Prop 13 restrictions on residential homeowner taxpayers. But I think on balance, there's no question that dealing with the loophole that was created by Prop 13 and establishing the split roll is an equitable and fair and timely reform of California's property tax system.
The next question, Ahmed, is for you. How easy would it be, legally speaking, to modify a risk assessment tool like an algorithm that has been demonstrated to be biased?
Assuming by modification, what the questioner means is eliminating the bias. It's difficult for me to imagine, although I'm not the designer of any algorithms, but it's difficult for me to imagine any risk assessment instrument that includes past interactions with the criminal system as indicative of a higher level of risk as being able to evade bias. The US criminal system has operated at multiple levels in a biased way for virtually its entire existence. And so figuring out how to reconcile that past with a present or a future that can somehow predict risk based on the past seems like a tall task.
One more question here. This question is about Prop 25, but could apply to any of the propositions. Do you think funders influence how we vote? I read that the top funders to Prop 25 are individuals with ties to tech. I read that Stephen and Connie Ballmer each contributed $3 million to the yes vote. Stephen Ballmer is an ex-CEO of Microsoft. John Arnold gave $5 million and is a hedge fund manager.
So on and I obviously welcome the other panelists' opinions here on the sort of broader question of funders influencing how we voted. I think there's an obvious yes answer there. In terms of the way that that funders are engaging here around Prop 25, I think there's at least some fear that some version of a risk assessment industry, although probably not quite as parasitic as the cash bail industry, could potentially emerge with various tech groups looking to one-up each other with algorithms that they claim are better and more predictive and have a higher success rate, as it were. I think that is a very legitimate concern, and there may be people looking to profit off of this shift or this prospective shift from cash bail to risk assessment instruments.
Jesús, Catherine, any thoughts in terms of the role of money with regard to the initiative process, yours in particular, that you're interested in, or more generally with regard to this form of lawmaking?
Jesús, you want to go ahead?
Yeah, I think if anyone who's watched TV recently, and if you're a baseball fan, you're watching a lot of TV, you're seeing all these commercials where the distortion and the amount of revenue that's being put into, in the case of Proposition 15, the no on 15 side, and the misrepresentations, the scare tactics, frankly, the abuse with respect to small minority businesses, they're the ones who are going to pay the price here, just totally ignores, excuse me, little fire station here, totally ignores the facts concerning who's going to pay higher property taxes. And here's some numbers. 92% of the revenue raised, so that's 92% of $12 billion a year that would come from this split roll, would come from 10% of all commercial and industrial properties in the state. And those are properties, massive properties by multinational corporations, many of whom aren't even housed, don't even operate fully out of California. And they're the ones who will finally be paying their fair share, and that will help in having the state be able to provide better public services.
All I would add in response to what Ahmed and Jesús have already said is that the initiative process in California was originally envisioned as a way to deal with corruption in the legislature and the perception, true then and perhaps still true, that legislatures tend to be responsive to the wishes of the wealthy and not responsive to the wishes of ordinary people, unless ordinary people are organized in some effective way, such as through a union. What we have seen, however, is that the initiative process is now subject to the same corrupting influences that legislatures are. And indeed, Proposition 22 is a perfect example of that. It is on the ballot because the app-based ride-hailing companies have spent $200 million getting it there. And that, as I already suggested in answer to the prior question, the perception that this is what riders want is one that has been manufactured through using the leverage that the companies have over their drivers. The one final thing I will say is that Uber and Lyft and a lot of the media coverage of them are famously, supposedly not earning a profit. The reason why they, if it is true that they are not earning a profit, the reason why they're not has nothing to do with what they pay drivers. By definition, they cannot lose money on the drivers because they take a percentage of what every driver provides. They're not paying a driver who is not giving a ride. So that what they are doing is using their drivers and the money they make from underpaying their drivers to subsidize other aspects of their business, like the development of self-driving cars, like expansion into other markets, like legislative campaigns to defeat the efforts of cities to deal with automobile congestion that has come about from the huge number of Uber and Lyft drivers on the roads in dense urban areas. And so what they're paying the drivers has nothing to do with the reason why they are not profitable.
I think that's all the time that we have. I would thank Catherine and Jesús and Ahmed for their wonderful presentations. Thanks all of you for listening. Take care and be safe, everyone.